Hello again, doctors. I'm Dr. Chris Rapoff of EZ QME Continuing Education, and I'd like to welcome you to this week's case law update. In the Lopez versus Porterville Sheltered Workshop, today's case involves a dispute between two defendants, and in this decision, the case hinges on the medical reports provided by both sides, where the Workers' Compensation Appeals Judge must determine if these cases qualify as substantial medical evidence. This may sound like a broken record, but here we go again. We have a case's ruling hinging on a determination of substantial medical evidence and its importance when we provide a QME report, but with a twist. Does the QME's flexibility in providing a conclusion make a difference here? Let's take a look at this one. Let's provide a little background as we get started. We have a 36-year-old gentleman who was working as a driver for the Porterville Sheltered Workshop. He filed two separate claims and submitted injuries for these claims, a specific injury of October 2009, which was accepted, and then he also submitted a CT claim from July of 2009 to June of 2010, and this claim was denied by the claims administrator. Both of these involved the exact same body parts, and they included the upper digestive tract, the colon, psych, left arm, left wrist, left hand, right arm, right wrist, right hand, bilateral legs, knees, and back. This is fondly known as skin and contents, and I think you get my drift when I say that. Let's see if you can follow some more of these facts. First of all, the applicant sustained a specific injury, as we've already discussed, with the multiple body parts, while he was employed as a driver by a company called Sierra Management. Now, Sierra Management was insured by Ulico Casualty Company. Ulico Casualty Company was liquidated, and another carrier, CIGA, took over handling of the claim. After some investigation, CIGA filed a CT application against Porterville Sheltered Workshop, as the applicant had had concurrent employment with it and Sierra Management. Porterville Sheltered Workshop was insured by another insurance company, Manufacturers Alliance. So we have a couple of insurance companies having some issues against each other in this case as to who's going to be responsible for payment. They both now have a CT injury claim that has been adjudicated. The actual lawsuit gets a little involved, but the key issue to keep in mind is, in this matter, it pertains to whether or not the applicant sustained a CT injury while employed by both Sierra Management and Porterville Sheltered Workshop. One QME opined that the applicant did sustain a CT injury as claimed by CIGA, who took over for Ulico, and the second QME opined that he did not. This is where the problems come in. The Workers' Compensation Appeals Board concluded that the applicant did sustain cumulative trauma injuries based upon the opinions of the first QME as claimed by the QME in the CIGA case. The petitioner in this case, who is Manufacturers Alliance, filed a petition that says they were aggrieved by the finding of the CT, and it should not have been there. It should have been the specific injury as originally filed. Now here the petitioner raises a number of arguments in an attempt to illustrate that the decision that the workers' compensation judge made initially was incorrect. For example, the petitioner noted that the QME in his report did not explain how or why the applicant sustained the CT injury while working for both employers. The Workers' Compensation Appeals Judge's response to that argument was how and why questions, as they're posed, are not a question that they can address. This conclusion requires an expert medical opinion, convincingly, in this argument by the QME representing SIGA, where the physician who opined that the applicant did sustain cumulative trauma injury while employed by both employers. So we have the Workers' Compensation Appeals Board saying that that's not their purview to determine the how and why question, it is the expert witness who is supposed to do that. In this case, it would be the QME. So the appeals board goes on to say that they actually could have addressed the applicant's job duties with both employers, but again, they deferred this opinion and they stated that a determination of whether or not there was a cumulative trauma injury requires an expert opinion, not a judge's opinion. Additionally, they even indicated that within the realm of medicine and not law, that the question of a CT must be addressed. The legal opinion comes in when the trier of fact must determine which physician's opinion is more convincing, not which one is right or wrong. So here the appeals board found that the opinions of the QME involved with the SIGA claim were more convincing as to the existence of a CT than the other QME. So doctors, isn't this very interesting? They ruled not if the opinion by the QME was correct, but which one was more convincing than the other. As I mentioned in prior case law updates, then if you can provide the receipts in your QME report, meaning you provide the how and the why when you provide your opinion, and you're convincing, you'll have a greater chance that will stand up and your opinion will stand up in court. Very interesting. So the appeals board just stated that actually in this case, the two QMEs just simply disagreed. The QME on the side of the Manufacturers Alliance finding no CT involving portable sheltered workshop, and then the QME associated with the SIGA side opining that there was a CT. And just because one expert opinions differed from another expert opinion does not render the findings of fact invalid. The petitioner also claimed that the QME involved in the SIGA insurance company did not stand by his opinions as he noted in the decision. Now, doctors, if you recall, the first QME opined that the applicant initially suffered a specific injury and then later changed his opinion to indicate that the injury was a CT claim and not a specific injury. This is where the petitioner has an issue. And of course, the appeals board had to respond to the petitioner, and they indicated that, yes, while it is true that the initial SIGA QME did not note the existence of a cumulative trauma, but instead initially said it was a specific injury, when he was provided with additional facts, the QME showed a willingness to modify his opinion. And they also pointed out that the SIGA QME did modify his apportionment opinions when he was presented with different facts, but never wavered from the finding of a CT injury after his original report. In other words, so what? And the appeals board came back with a pretty substantial ruling, and I put it in quotes because it is important. They stated that the mere fact that the doctor was willing to modify his opinions based on new or different facts presented to him only showed his flexibility and willingness to listen to the parties and modify his opinions accordingly. That alone provides more credence to his opinions. Wow. And so the petition for reconsideration was denied. Very interesting. Now, what are the takeaways in this case? That's a very interesting case indeed. Several important takeaways, I think, in this reconsideration ruling, but really three come to mind. Number one, it is the expert's medical opinion whether or not an applicant suffered a specific or CT injury. It's not a question that the court can address, as they indicated. So this is very important when we talk about causation and we answer the questions in the discussion section. We need to be specific. Number two, a legal opinion comes in where the trier of fact, of course that's the judge, must determine which expert opinion, in this case the QME, is basically more convincing. Now you notice they did not say more correct, but more convincing. Keep that in mind in your next report. And third, modifying your opinions based on new or different facts as a QME demonstrates your flexibility, your willingness to listen to the parties, and to modify your opinions accordingly. We also know that, in this particular case, this willingness of the QME to change his opinion provided more credibility to his opinions. I think this ruling is a teaching moment for all of us. So my suggestion to you as you write your next QME report, keep in mind that a convincing conclusion, then additionally supported by the how and the why you came to your conclusion, is of the utmost importance in the eyes of the appeals court judges and the workers' compensation judge as well. So, by the way, you'll also qualify your report for substantial medical evidence. That cements your place in the workers' compensation community as a QME that knows what they're talking about. So once again, doctors, I hope you enjoyed this presentation. I hope you can take something from this case and use it in your next QME report as we strive to provide the best, most accurate QME reports in the industry. I'm Dr. Chris Rapoff and wanted to thank you for taking the time to join me in the presentation. I hope you enjoyed it. I look forward to sharing another one with you soon. And until then, take care.